In this video, we are going to discuss how naming a guardian for your child can still leave them at risk. I'm attorney Sarah Siedentopf. I'm an estate planning and probate attorney in Atlanta, Georgia. Obviously, you want to name a guardian for your child, but are there ways that they are still at risk, even if you've done so? And the answer is maybe. And the first risk is that you only named one person. That means that if something happens to that guardian, who is often a family member or a close friend, so that you could be at the same, on the same vacation when something happens, then we don't have a backup. So that's the first risk that's out there, is not having backups in place. The second risk is that it's been a long time since you named that guardian. Circumstances have changed. They're no longer physically able to in the case of an aging relative. You're no longer as close to them, and perhaps in the case of a friend or someone where you were, very close, but you've moved, you're no longer quite as close. It's not an appropriate guardianship relationship anymore. So circumstances have changed and you haven't updated it. Another possibility that might leave your children at risk is that you've put the same person in charge of the child and of any money that you leave to the child. Often, this is 100% appropriate, but having the same person in charge of both doesn't give you two different adults looking out for the best interest of the child, checks and balances, how is the child being taken care of? How is the money being spent? So leaving the same one person in charge of both makes it much harder for anyone else to tell if appropriate expenditures are being made. And the last thing that might be leaving your child at risk is that it doesn't provide for emergencies that happen while you are alive and can't take care of them. So, the first thing, we can fix it. Just add backups. And I do realize that it is easier for me to say than for you to find multiple people you would trust with your children. But if at all possible, please do add backup guardians. The second thing being, take a look at your documents every now and again. And if you realize that the guardians that you did name are no longer appropriate, update your documents. The third one is a lot harder. Deciding, do we name a separate person as guardian of the child and, trustee or conservator of any money that we leave to them? Because sometimes it really does make a lot of sense. It's the same person who is responsible and a good choice for both of these jobs. But other times it makes sense to name two separate people, and so it is a hard decision. So that's not necessarily one that you can fix, but it is one you should think about. The last one, it doesn't cover your child and leaves them at risk during your lifetime, can be fixed here in Georgia with the designation of standby guardian. This is a separate document that says, if something happens to me and I'm physically or mentally incapable of taking care of my child, but I'm alive, who should take care of them? It only lasts for 120 days, so it is short term. It assumes that you are going to get better and be able to take care of your child. If that is not the case, someone will actually have to go to court for a permanent guardianship. So that would be a separate thing. But it takes care of them in the short term and basically nominates, someone to be acting on behalf of your child. Maybe this person isn't the one who is going to take care of them long term, but they are the person who's going to get the ball rolling to say, hey, we need to do something about this. So these are ways that just naming a guardian for your child in your will might still be leaving them at risk. If you want to talk through best options, update paperwork, do new paperwork, please give me a call. Thanks.